Um, as most of you know, my name is Anouar Majid, and I am the director of the Center for Global Humanities, a public forum for the discussion of ideas that matter to our lives and communities. The Center exists as an antidote to sound bites and cliched opinions, and I need to emphasize this because I think it's critical, particularly in the times we live in now. We believe that reading, thinking, writing, and debate are indispensable to any enlightened society, which is why we are proud to support and partner with the Maine Humanities Council, whose director, Eric Jorgensen, is gracing us with his presence tonight. So, welcome. This seminar is the last main event of our second season. Yes, it's hard to, it's kind of difficult to realize, but we've been doing this for 2 academic years already. And we could not have kept going without your engagement. Engagement is what keeps art and culture alive. So I really want to thank all of those of you, the participants who come regularly to these events, for supporting the Center for Global Humanities. We also owe a huge round of applause to the UNE undergraduate students who braved the distance from Biddeford to attend, to join us here and attend this series. So they are all seated there. Some of them are here too. It's okay. These are the students who have committed to a whole year of, those students who have committed to a whole year of the seminar will be declared Center for Global Humanities Scholars at a reception next week. The reception will take place in the Art Gallery the same time at 5 p.m. So you're cordially invited. At 6 p.m.? At 6 p.m. So you're cordially invited to the reception next week at 6 p.m. at the Art Gallery to celebrate the conclusion of this season and also to celebrate the accomplishments of those brave students who have taken 2 semesters of the Center for Global Humanities seminars. The students who are seated there and also there have had the good fortune of being tutored by my colleague and friend, George Young. And the quintessential, I took a few notes just before I came down, the quintessential cultured man, a seasoned professor who taught at Grinnell and Dartmouth before he came to UNE. And so to him, I also owe a great amount of gratitude and thanks. Thank you. The Center also owes a huge deal to the guy there in the back, Neil Jandro. He's wearing a suit today and a nice tie. He is officially UNE's webmaster. That's his job description on the website if you go to UNE's website. But he is also a fervent believer in the role of ideas in a progressive society. And I've known him long enough to know that he's totally committed. And most of the work you've seen him do in this forum is out of his own volition. It's not part of his job description. It's just his commitment to the enterprise of the Center for Global Humanities. He is also the guy who directs the video streaming and archiving and the audio system in this room, as well as the Center for Global Humanities website. So I owe a tremendous amount to him, and I think without his technological support, I don't know what I'll be doing. I mean, it'll be very difficult to reach a lot of you in this audience. Rolly Masseth, who's also, I don't know, is he in the back there, Neil? Oh, and David Diego, both of them have been also working very assiduously to help support the center in technical ways. So I owe them a great deal of thanks for their contributions. I also, last but not least, is Liz Bennett. She's here with the green jacket. She corresponds with every single speaker who comes to these events. She arranges their trips. She books their flights. And she also does a lot of work. I mean, I'm sure most of you, I'm sure Adrian knows the amount of work she does to facilitate people's trips. Behind her is Susan Piter, if I say it correctly. It's a big challenge to say her last name, but she is the official photographer. She's actually, her arms had to be twisted to be the photographer of this event. She's not a photographer by trade, she's a writer by trade, and we're all looking forward to the great book that is gonna come out of her incredibly inventive mind. But I think she has done a tremendous amount of, she's given us a tremendous amount of support by taking pictures and making, and so immortalizing, so to speak, the events that are taking place at the center. And just 2 rows behind her is my wife, who very rarely shows up. But because we have 4 children, and I just discovered today that Adrian too has 4 children, around the same age. So let me give you a little sort of little idea what's happening next season. And the reason why we need the technical support, we're going to be renovating this room, we're going to be improving on the audio and the visual capabilities of this lecture hall, because next season we are expecting another impressive group of speakers. Pauline Mayer will be speaking here in September from MIT. We'll be talking about the process of the ratification of the Constitution. Patricia Limerick, a very prominent scholar on the West, will be talking about the uncertain fate of the great American desert. Dan Cohen from Colby College, and we make a point of trying to invite our colleagues from other colleges and universities in the state. We'll be talking about how to lose an argument. And of course, the next speaker does not need a lot of introduction. Noam Chomsky will be talking. The topic has yet to be determined because we're waiting to the last minute to see what's going on in the globe to decide what topic would be most suitable for the event. And Craig McEwen from Bowdoin. Some of you may know him. He's really talking about solving problems, resolving disputes, and finding justice. Emily Martin from NYU will be talking about bipolar expedition, mania and depression in American culture. And Nabil Matar from the University of Minnesota will be talking about Europe through Arab eyes. He is one of the world's leading figures on this subject. In addition to these seminars that I've just listed, there will be lectures by other prominent thinkers and speakers to complement this series. So it will be a very exciting 3rd season. And so get ready and stay healthy, right? And not just for September, by the way, but also for tonight's seminar by Adrian Johns on the crisis of intellectual property. I invited him almost like a year ago or so. He sounded a little amazed that I would invite someone a year ahead of time. But that's what we do at the center, because we need us to have a program that is way ahead of time to make sure that you all know about it and prepare for it. Now, Adrian Johns is professor of history and chair of the Committee on Conceptual and Historical Studies of Science at the University of Chicago. He is interested in the history of the sciences, history of the book and media, intellectual piracy and property from the Renaissance to the present. He is author of, among other works, The Nature of the Book, Print and Knowledge in the Making, which was published in 1998, Piracy, the Intellectual Property Wars from Gutenberg to Gates, which was published in 2010. The latter book, this book, addresses the history of intellectual property and its enemies from the early modern period to the present, arguing that today's conflicts over IP are deeply rooted in the development of modern political and cultural systems. And just in the process of talking to him today, I discovered he just published another book, which came out, which is a little piece of this book that was left over, so to speak, from the last book. It just came out from Norton a few weeks ago. It's called Death of a Pirate, the British Radio and the Making of the Information Age. And it sounds like a fascinating book about the offshore ships that acted as regular radio stations during the 1960s and the kind and what happened to them. So without further ado, it's my great pleasure to introduce to you Adrian Johns, the last speaker of this year's seminar series.
So thank you, Anouar. Thank you, Center for Global Humanities. Thank you to the UNE community for inviting me to this occasion. What a spectacular set of speakers you have for next year. It makes me want to just kind of relocate out here. Anyway, so I want to talk about a key element in what you might think of as the infrastructure for creativity on a global stage. A major part of the infrastructure for really making any kind of ideas and then transmitting them across the world is intellectual property. You'll all be familiar with that. It's a concept now that pervades discussions of the information economy and information culture. And as you'll also be very well aware, it's a very controversial concept. If you look at media representations almost every day, you will find not just that intellectual property is a central element in how we live now, but it's one that's continually contested. So you find, upholders of very strong copyright protections, for example, warring against hackers and pirates and things like that across the world. And these intellectual property controversies are notoriously intractable. They're not particularly new, although we tend to think of them as such, and there's not really any sign that they're going away. And that matters, that intractability, because it means that really at an everyday level of how we live, there is basic uncertainty. When we go to say, copy something for a class, if you're a professor, you have little twinges of doubt about whether what you're doing is legally sound or morally sound or not, and whether it matters whether it's legally sound or morally sound. So there is a kind of uncertainty that dogs even quite mundane actions now, because we live in an information world and because intellectual property is really the basic infrastructural core of that world. Now, I want to argue that while this situation is clearly affected by the digital revolution and also by things like the biotechnological revolution, it isn't reducible to being just an effect of some kind of technological change. It isn't just because we now have digital networks that intellectual property is so much a predominant concern and is so controversial. Nor is it a product directly of legal doctrine. It isn't because copyright, say, is a problematic legal doctrine that it's so controversial, though it is a problematic legal doctrine, and it has been ever since it was invented in the 18th century. Instead, the controversies and the intractability of those controversies, I want to say, comes about as a result of practices through which intellectual property is manifested down to quite basic everyday levels of action, and in particular practices related to detection and enforcement. So I think when we talk about intellectual property, we should talk not just about legal doctrines or about the technological properties of networks, but about how, in fact, intellectual property is made real through its policing. And that's what I'm going to talk about today. Now, the practices of policing intellectual property have long histories. In fact, I want to say that what intellectual property is, in a real sense, reflects those histories, as much as it reflects something like conceptual discussions of creativity or the psychology of originality or something like that. In other words, while one tends, I think, to think that enforcement or policing practices are law in action, in the case of intellectual property, it's almost the other way around. Law is fossilized practice. And one of the reasons why we have such a problem with intellectual property now is that it is fossilized. It's a fossilized version of practices that made sense maybe in some previous generation, but they don't make sense so much now. And the crisis of intellectual property that exists, not just in the United States or Europe, but worldwide, is indeed a crisis, an existential threat for that reason. It emerges from issues that are very deep-seated indeed in modern culture. They don't just reflect the current state of technology or something like that. And these are issues that may even be central to the definition of the good society itself. And one of the things that I'll be stressing as I go forward is that they're in some sense very traditional, these issues. They're not only not new in the sense of being just to do with the wonders of digital technology, but they're actually very traditional indeed. They have to do with some of the basic values of liberal society, like freedom of speech, privacy, citizenship, things like that. So to begin with, how do you uphold intellectual property in a world where digital networks have spread without limit, it seems sometimes, and they allow for unlimited copying and unlimited distribution at almost zero cost? It's a basic problem. Here are 3 examples which, in the spirit of this being a global humanities talk, I've taken from 3 different continents. So first of all, California 2007. Media Defender describes itself as the leading provider of anti-pirate solutions in the emerging internet piracy prevention industry, or IPP. That idea that there's an internet piracy prevention industry is one that I want to lodge in your minds. So Media Defender is a company based in Los Angeles that was founded in 2000, and it's built up a thriving business devoted to what it calls decoying, spoofing, interdiction, and swarming in the service of intellectual property owners. For example, it may serve up fake movie files to the net so that anyone looking for a particular movie, Avatar would be the one du jour, I guess, will find countless false versions and in the end give up. It works to put these spurious versions high up on search engine answer lists. Or it might mount something similar to a denial of service attack, deluging a BitTorrent server with requests in order to delay any other users getting a specific file. A denial of service attack basically means you bombard a particular site with requests so fast that it kind of throws up its hands and shuts up shop. In 2008, for example, Media Defender brought down the entire operation at what was actually a legitimate internet television company called Revision 3 in San Francisco. Apparently because Media Defender's systems automatically saw Revision 3's server, which was a BitTorrent server, as a distributor in its terms, and assumed furthermore that what was being distributed was piratical, so it just kind of went after them in a Terminator kind of way. The FBI looked into this case but ended up not leveling charges. The company has anyway worked extensively with movie and music companies and is a favorite target as a result of hackers and the more kind of energized branch of hackery known as the hacktivists. An indication of why came in 2007 when Media Defender quietly created a BitTorrent site of its own called Mevi. And it was secret. Media Defender's involvement in this was very secret. Now, what exactly this BitTorrent site was for remains a little unclear, and the company itself later claimed that it was an experimental venture not meant to be publicly visible. But critics contended that it was designed to attract uploaders, that is, it would attract people to upload pirated movies, and that the idea might be to collect their internet addresses to then sell them on to movie companies and things like the MPAA, the Trade Association for the Movie Industry, which could then exercise enforcement against them. At any rate, Media Defender's role in Mevi was, as I say, extremely secret, and it looked like another anti-corporate subcultural node, rather like the Pirate Bay, until hackers got hold of 700 megabytes of company emails and made them public, revealing this link, at which point Media Defender's chief responded in one of these emails that the site was, in his word, now fucked, and it went offline pronto. Now, second example, India, 2010. India, as you know, has a big film industry, Bollywood. Now, in 2010, Bollywood got together and announced that it would begin, as it put it, using pirate tactics to beat the pirates. It would employ cyber hitmen to attack the websites that were distributing unauthorized files of its movies. And it hired a company called Aplex Software to discover these sites, then to send cease and desist letters, and then to attack the 5% of BitTorrent sites that ignored the letters. So this company's software began trawling the internet, looking for telltale links to new movie files. And when it found them, it would send letters and then go after the sites, typically using denial of service assaults to cripple these sites, and at the extreme actually trying to destroy the files themselves. But this, of course, is a problematic strategy, as Media Defender has found. A denial of service attack involves sending millions of requests for responses and so clogging the target site up. It's not quite the same as a distributed denial of service attack, which has become notorious in the press as the kind of weapon of choice of hackerdom. But it is similar, and in some countries it's actually illegal because it damages network communications by computers. And it's certainly controversial enough that even some copyright enforcement organizations have disowned it. It also leads to retribution, it turns out, in today's world. Because in response to Aplex's denial of service attacks, especially on the Pirate Bay, Anonymous, the now notorious kind of crowd group based on 4chan originally, launched its own distributed denial of service attack against Aplex using a low-orbit ion cannon, which is a piece of software that anybody can put into their computer and which will recruit you into Anonymous's kind of attack cadre. You put in the address that you're attacking, and it then helps with the denial of service charge. The name actually comes from an online video game, of course. This was the beginning of what Anonymous called Operation Payback. So it took down Aplex's site temporarily. It then went on almost immediately to assault the MPAA and the RIAA, the trade associations for the movie industry and the record industry in the United States. And it attempted to Google bomb the head of the MPAA. That is, an attempt to associate by repeated searches two concepts that might otherwise be not associated. In this case, the concepts that were going to be associated were the identity of the head of the MPAA and child molestation. Operation Payback then continued and expanded to target Media Defender, that company from 2007, and it took on a high-profile role in 2011 when it became the big defender of WikiLeaks and targeted things like MasterCard, because MasterCard had excluded WikiLeaks from its financial systems. So the third example is London, 2010. A law firm called ACS Law, allied with another company called MediaCat, persuaded copyright-owning corporations to authorize them to pursue file sharers, proposing to split the proceeds with a massive 65% actually going to ACS and MediaCat. Now, this campaign was based on a practice that was actually pioneered in Germany in the mid-2000s by a company called DigiProtect. What DigiProtect did was to gather usage data from internet service providers and send thousands of letters to citizens across Europe, including Britons. And some of these citizens were like children and old-age pensioners, accusing them of downloading copyrighted files, in particular copyrighted pornographic films. It would then demand £500 each not to pursue legal action. And of course, many recipients, especially in Britain, this being Britain, were too embarrassed to protest, and it seems that DigiProtect made good on its corporate motto, which at that point was, turn piracy into profit. Now, like DigiProtect, ACS Law in 2010 exploited data collected by internet service providers. It demanded that these providers reveal the street addresses that were associated with particular internet addresses at which downloads had purportedly occurred. And this was a demand that several ISPs balked at because they know the implications, not least that with many houses having domestic wireless networks that are insecure, any outsider could in fact piggyback on a house's internet address without the householder being involved at all. For example, this is the case with me. I mean, I live in Chicago and I have a household wireless account that is not security protected. And I figure I'm okay because the people who live next door to me are actually a household full of Catholic priests, and of course Catholic priests would never do anything bad. No, actually, they're very sweet. And they did actually come round, one of them, once to confess to me that he'd been using my wife. Anyway, but many houses have accounts like that. So it's by no means simple that you can go from internet address to physical address to individual, determinatively. But this is what ACS Law was doing. It sent out about 10,000 letters to Britons in January 2011, by January 2011, accusing them of illegal downloading, especially of pornography. And under a business model that it called speculative invoicing, it demanded £500 from each of them, so there hadn't been much inflation there. And this tactic seemed set to spread because a second UK firm called GCB then mounted on the bandwagon and sent out more letters, some of them to the same people, actually. Now, many of the recipients of these letters, where they weren't too embarrassed to say anything at all, claimed that they were innocent. And before long, the Consumers Association decided that they were right, pointing out that if these people were guilty, how come ACS Law never took anybody to court? And as controversy spread, ACS Law found itself attacked by hackers, especially when Anonymous added it as the latest target in its payback campaign, which by now has gone from Aplex to the RIAA to the MPAA to Media Defender, now to ACS Law. And when Anonymous hacked into ACS Law, which it did with great ease, actually, the personal details of thousands of its targets, along with their alleged pornographic preferences, were issued online. Now, in the end, ACS Law did actually sue some people. It nominated 26 defenders, downloaders, in a court in London, but almost immediately the company itself moved to dismiss its own case, at which point the legal process turned against it. The judge refused to end the trial, remarking that he got a stronger impression with every twist and turn that ACS law's manoeuvrings really reflected what he called a desire to avoid any judicial scrutiny, and he feared that it brought the legal profession into disrepute. ACS law reacted by abruptly shutting down altogether. It no longer exists. And it did this just before a verdict that was set to grant the defendants costs. Its one lawyer, a man called Andrew Crossley, claimed to have received threats of violence, but certainly by that point the professional body representing British solicitors was mounting an inquiry into Crossley for misconduct, and Whitehall's information commissioner was looking to impose a fine of up to £500,000 for failing to secure private information. So those are three examples, and they show something of the ambivalence of these policing efforts, and they relate to Europe, India, and the United States. And you can find similar stories to this in other parts of the world as well, not just in digital media too, but in other information sectors, things like agriculture and pharmaceuticals, biotechnology. We could add, for example, efforts to restrain software piracy in Russia, where Microsoft, as reported by the New York Times last year, has found itself uncomfortably close to a state security system more interested in tracking dissidents than pirates, or to the policing of TV watching in Canada, or copyright trolls in Nevada, any number of similar instances. So these are not isolated episodes. They're actually rather representative, and they raise serious questions about the role and implications of intellectual property policing. Most obviously, these are cases of private enforcement as a profit-making enterprise, practiced typically without judicial oversight, and when judicial oversight is extended, sometimes to the disadvantage of the enforcers. But in late modernity, private policing is all the rage. It's being incorporated into legal systems themselves, so that dichotomy is kind of dissolving. For example, one reason why this ACS law case in the UK was so controversial is that at the same time, the Digital Economy Act, a new law, was going through an appeal process, actually at the instigation of the internet service providers. Because this new act, the Digital Economy Act, would actually enshrine private policing via access to internet service provider data on addresses. So in other words, it's, as I say, dissolving that boundary between the public and the private enforcement efforts. There's a well-known term, 3 strikes, that refers to moves to decree, as it were, that internet service providers should cut people off from the internet when content companies tell them that they're regular downloaders, that you would get 2 chances and then on the 3rd chance you're out. And 3 strikes would be based on this kind of detection system, and typically without judicial review. ISPs themselves are against the idea, which is why in Britain they were the ones who were appealing against the law, not the pirates. It has obvious civil liberties implications too in any society that is comprehensively networked, but it is spreading. For example, France implemented something very like it in a recent law known as Adopi, after the agency that's charged with implementing it. And New Zealand recently passed one too, although their actual disconnection would require a court hearing. These kinds of implications were to the fore too in the long controversy over the Anti-Counterfeiting Trade Agreement, or ACTA, which was negotiated in secret at American insistence between the US and other powers as an international enforcement protocol autonomous from the United Nations, the World Intellectual Property Organization, the WTO, and other authorities. For a long time, it looked as if ACTA was going to include an explicit commitment to a 3 strikes principle. Now, as it's happened, in the end, it hasn't included that, but how it's implemented how ACTA is implemented is actually still rather up for grabs. Now, on the one hand, these kinds of practices and proposals reflect a fantasy of total information awareness, to use the title of a defunct Pentagon program. The assumption seems to be that tracking technologies are precise, accurate, flawless, and intrinsically disinterested, and that internet addresses map straightforwardly onto individuals. On those premises, copyright justice, or patent justice for that matter, might indeed be automated, and it might not matter who does the monitoring. But on the other hand, reality is evidently somewhat different in kind as well as in degree. What's actually happening is increasingly something more like a Hobbesian power struggle, in which it's difficult to tell the pirates from the police. For example, when Aplex attacks pirates with denial of service attacks, only to find itself the target of a massive denial of service counterstrike, both the weapons and the tactics are indistinguishable. And so to some extent is the rhetoric. You know, both sides here talk about freedom, integrity, standing up for humans against big anonymous forces. So where does this reality come from? And I think, interestingly, where does the indifference to this reality come from, too? Now, for answers to those questions, we need to turn to the long-term history of intellectual property policing, a history that's in fact longer than the history of intellectual property itself, strictly speaking. The phrase intellectual property is a 19th century phrase, actually. It doesn't go back earlier than that. Now, the distant origins of today's intellectual property policing systems lie in the Renaissance in Europe, and in Italy in particular. The earliest patents are usually said to date from roughly the 15th century in the Italian city-states. Patents were manifestations of royal or state prerogative, each one being a kind of particular utterance on the part of the monarch, given to some particular individual to protect their unique ability to do some particular thing. They weren't particularly associated with inventions at first. By contrast, guilds, trade associations, trade companies, created registration systems that provided a similar kind of protection, but for only people within their fraternities, their particular industries. And they drew their legitimacy not from the state, but from the continuity of a craft. So their authority extended no further than the membership of the guild concerned. So, for example, before the invention of copyright, which is an 18th century thing, if I wanted to publish a book, I could protect myself in two ways. I could either go to the king and say, I need a particular bespoke patent, a letter to me, giving me the sole right to it. Or I could go to the Publishers Guild and register the title, probably to my publisher, who would then get the right to it. But that's not a legal right. That's a conventional right by the trade. Now, those two things are actually politically incompatible. And in the 17th century, they did come into conflict, one result of which I'm not going to go into, was the invention of the concept of piracy itself. For present purposes, however, what matters is what they had in common, which was that in both cases, the patentee or the craftsman, the registrant, had to act to defend the patent or the register against violators. That didn't happen automatically. So sustaining literary or creative property as property at all depended on owners actually doing things. And much of the history of intellectual property enforcement derives directly or indirectly from that fact. Because, as is well known, there weren't any professional police forces in early modern Europe. Each city had its own arrangements for keeping order and enforcing laws. So in England, the place with the most direct connection to subsequent American history, what made lay enforcement practicable was a presumption of social circulation. The idea was that upholding a property, say, in a book, would be the duty of the guild officers. And who held the offices in the guild was a matter of rotation. So if I held the office one year of warden, and I went out and victimized some supposed pirate printer one year, it was quite likely that that person would be elected to the same office the next year and could do the same to me. So what the apparent stability of what we would call intellectual property rested on was a principle of do as you would be done by. And a threat, actually, implicit in that the next year, whatever you did to somebody else would come back and haunt you. It was a matter for these trade officers because they had the knowledge to go into things like printing houses and bookshops or inventors' workshops if it's a matter of engineering, and they knew the people who were working there. This question of access was actually critically important, and it was seen as critically important at the time, not just in this domain, but in all domains of politics. Guild officers had the right to search members' premises. So if you're a publisher, the people who can go into your publishing house are fellow publishers, not state constables. And in fact, in the 17th century, there were long political debates about this, in England in particular. So the right to search is a right that the state's officers, the state's police, such as they were, didn't have. Trade officers did have it. And if they found piracies, then what they would do is they would take the pirated books to a central court run by the trade, where punishment would be meted out, typically the destruction of the whole edition. You couldn't go out of this private court into the larger legal realm without risking being blacklisted from the entire industry. As a result, the policing of literary property, as it came to be called, was a profoundly secret matter. Authors and readers had no idea that this was going on, and so they tended to think that print was as it were, self-ordering, simply because they didn't see the struggles. Now, this kind of participant enforcement remained normal across Europe through the end of the 17th century, and it bore certain consequences. For example, despite a lot of rhetoric about sedition, states were quite willing to recruit pirates as policemen because this is what the trades did themselves. So, for example, in 1688, the master of the Stationers' Company in London, that is the most senior publisher, and actually the King's printer himself, was a man called Henry Hills, who was notorious for stretching the law. And he'd been nominated by King James II because he was one of the King's few Catholic supporters in the trade. In general, literary property was assumed to be a matter of privy knowledge. It was a field notorious for informers and turncoats, and it was attended with something of the disrepute that these kinds of antisocial types endured. And that issue of access, as I said, it was especially fraught. Guild officers like Sir Roger Lestrange, for example, who was the government's chief censor, railed at length about how printers were basically self-serving in having this kind of knowledge, and he wanted general warrants for his police to go into the printing houses, and he never got them. And in the end, he was one of the targets of the revolution in 1688 and was driven from office. Patents on machines and medicines were rather similar in enforcement strategies. Here, too, enforcement rested on the initiative of informed individuals, in this case patentees, who might be inventors or gentlemen rather than tradesmen, and on the use of inside knowledge often gained from informers. And it required money, expertise, patience, and constant attendance, but there wasn't a kind of public police element to it. But it was an essential activity because a patent itself didn't really confer very much. It was only regarded as giving a secure right once it had been tested by the courts. So it could be in the interest of the patentee actually to have a challenge. So these challenges became endemic. In the 18th century, though, the principle of participant enforcement fell into doubt and then into disrepute, partly because of the rise of political theories of interest and reason of state, which were seen as Machiavellian. So there gets to be an increasing notion that states can be corrupt and self-interested, for example. But also because of successive actual scandals. One thinks of Jonathan Wild, who was recruited to track down highwaymen and ended up being a highwayman. In the same generations as these, the practice of policing literary property and patents changed too, but in a rather different direction. Proponents in this case tried to extend participant policing to a national scale. So in 1710, Britain passed what's usually called the world's first copyright law, and that's right, though the term copyright doesn't actually exist in it. What followed were 50 or 60 years of debates about reprinting, because what the copyright law did was it said that for a new book, you got an exclusive right for 14 years to it, possibly renewable for another 14 years if the author was still around. In the 1730s, books began dropping out of this statutory protection. But the London publishing industry believed that underneath that statutory protection limit of 14 years or 28 years was a deeper common law right that rested in nature itself. It was part of the nature of creativity that it gave rise to an exclusive right, which they then bought from the authors. And that right lasted forever. It was property. So they called this literary property. But they were challenged by Scottish and Irish reprinters who claimed that the formal limited term copyright was all there was. And at the end of that term, things became open and public domain. So they started reprinting things like Shakespeare and Pope and so forth. So through the mid-18th century, there are ferocious battles about this. And it climaxed when the London trade entered into what their opponents called a conspiracy to eradicate piracy, which proved catastrophically counterproductive. About 60 London publishers signed on to a scheme subscribing £3,000, which was a lot of money at that point, to deny the pirates a market. They hired a kind of army of what they called agents to go out to every bookshop in the country and see whether there were pirated books on the shelves, that is, books that were produced by the Scots and the Irish and the provincials. Anyone harbouring these books would be prosecuted mercilessly, they were told, and all should take care for fear you are informed against. This was a warning letter that was sent out to every bookseller in the country. Now, significantly, the Londoners did pursue legal action at this time, but the case was entirely a contrivance, and in fact, the High Court disdained even to hear it. What was really the heart of the initiative was this extra-legal searching campaign and the campaign of threatening letters. And it provoked enormous resentment. In particular, it galvanized an Edinburgh bookseller called Alexander Donaldson into assuming the mantle of pirate-in-chief and mounting a counterattack. Donaldson got hold of a copy of that threatening letter and reprinted it so that, as he said, the world may see how unjust their pretensions to an exclusive right are and how oppressive in these lands of liberty their monopolizing schemes have been. He contended that a property regime resting on trade combinations and monopolies and extortion and battalions of agents intruding into private homes across the land, which was not a legal right, was more of a threat than piracy could ever be. In other words, it was the so-called pirates who upheld the public sphere and hence Enlightenment itself. And that's the first time that that argument was A, systematically made, and B, systematically believed. So for the first time, a principled rejection of literary property on Enlightenment grounds found real purchase, and it rested on practices of policing, not, or at least not immediately, on copyright's conceptual structure or on some technological issue. It's entirely to do with resentment at this claim to be able to enter people's houses. And that claim itself was a spatial expansion of a right that had existed consensually in London itself in the 17th century. It's when you expand it out to the whole country that people see it as tyrannical. That spatial aspect is worth noting because it keyed in with something that the Scots felt very strongly about in their reprinting. They claimed that the Londoners were trying to make Scotland into a cultural colony. As Lord Keynes, one of the great Scottish Enlightenment judges, said, London's apparent determination to crush this manufacture in the bud had a specific meaning. It would make of Scotland the cultural counterpart to, say, the American colonies, which were not allowed to produce manufactures of their own, but were simply to be raw material suppliers to the metropolis. So you start to see arguments relating literary property to colonialism, to political economy, to nationhood. And again, all of these come about because of enforcement attempts, practical enforcement attempts, not doctrines or concepts in the first instance. And they have to do with the extension of literary property, what later got called intellectual property, across political space. So prior to 1710, literary property regimes were specific to particular cities, and at that point they were fairly consensual. You know, the trade officers could go into your houses. It's when the spatial extent extends out that they get much more resented. And it was also why, when the Londoners sought stronger statutory protection, their sole success was actually a measure that had to do with customs at the borders of the country. For much of the 18th century, it actually became illegal to import books, even as a private citizen, into England, because the publishing industry won a law from Parliament saying that all imported editions of works previously published in England were contraband. They were decreed to be piracies. And of course, customs officers had no idea which books had been published in England first, so they just confiscated everything. And we actually have the lists that they wrote down of just travellers who were coming into the country with a chest of books, and we would find them all confiscated on this rule. And this was what an inability to pass domestic thresholds had to mean if literary property, that rather ideal thing, were to be upheld in the real world. You had to have intrusive and sweeping actions at national borders. And as with other things, this applied not only or even especially to texts. It had long been accepted practice for regimes to give patents to individuals introducing new trades from other countries. So you can get a patent not just for inventing something, but for bringing it into a country where it hadn't existed before. So rival cities and states vied for the knowledge possessed by skilled engineers and artisans by offering them these kinds of patents. At the same time, they forbade the expatriation of artisans or the export of machines and designs of machines. So this became part of a kind of European great game. It's very famous, for example, with the glassmakers of Venice, who were threatened with death if they moved off their island to other city-states. But the English had a rule which more or less made it treasonous for artisans to leave for America, for example, in the early national years of the US. And manufacturers themselves created trade associations to limit access to what they feared were international industrial spies. And they were quite open in confessing that these measures struck directly at ideals of the free exchange of knowledge, which was central to Enlightenment, but they didn't care. So this is as much to say as the relation between practices of intellectual property and political space were transformed in the Industrial Revolution, and we're legatees of this. Early modern participant policing worked when it was local to precinct and ward, and now it didn't because it was cosmopolitan. And the ideologies of Enlightenment, which were supposed to be boundaryless, ran up against those kinds of practices. So the call went up for first regional and then national and then international regimes of patent and copyright policing. Those regimes began to take place in the 19th century in the context of increasing industrialization, so industrial publishing as well as industrial manufacturing. So they climaxed in the late 19th century with the Berne Convention covering texts and the Paris Convention covering patents, which are the basis for the transnational intellectual property regime which still exists. But what's interesting about this is that it creates something like a two-pronged process that's been very characteristic of the modern age of intellectual production. On the one hand, there is an increasing movement to, if you like, globalization, to see intellectual property as transiting national boundaries, and to have institutions that recognize that, like Bern, and now the World Intellectual Property Organization, or ACTA, if it comes into existence. But on the other hand, the ground-level enforcement of these intellectual property systems remains very much a matter for private enterprise. So, for example, in England in the early 20th century, the most notorious forms of pirates were actually pirates of sheet music, who produced millions of copies, by some counts actually 1 billion copies of popular songs, led by a man called Frederick Willits, who ran a people's music publishing company distributing pirated music across Britain on railway lines. And Willits actually went to Parliament and testified in Parliament for a long day of interrogation about how this was a popular good thing. It was operating against monopolies and in the interest of working class creativity, because working class people now had pianos and they could play this music. The prosecution, though, still fell to the victims, the music industry, the publishing industry itself, which hired gangs of retired police, organized them into what it called commandos, and sent them out around the country to bash down people's doors, overturn market stalls and the like. And again, as in the 18th century and as in the 17th century, the real issue became not intellectual property per se, but assault and battery. So when the pirates were brave enough to counter-sue against the pirate police, they often won. For example, one magistrate declared that the publisher's policy was one of organized hooliganism, and another one lamented that the liberty of the subject is becoming of no regard at all. Assault and forced entry, it seemed, was an altogether more serious matter than piracy. So this attempt to employ an army of agents to stamp out music piracy raised constitutional complaints, at least as serious as those of Donaldson's time in the 18th century. But unlike their predecessors, the publishers did in the end win their fight with the pirates in about 1900. And they won because the state stepped in. In 1909 to 1910, both Britain and America saw new laws of copyright passed that made music copyright a criminal matter, and hence part of the remit of that new agency, the public police force. Around 1900, one therefore sees the beginning of what's continued as a major twin-pronged process, as I've said, of the modern era. The first is the continued existence and, in fact, growth and agglomeration of a private industry of intellectual property policing, extending its bounds beyond those traditional early modern limits, with its own professional experts and strategies, and as I'll say in a minute, technologies too. And secondly, and inseparably from that, in fact, and in fact often provoked by it, the increasing assignment of intellectual property piracy policing to the realm of criminal investigation and hence public police. So by the 1960s, you will find the police, the regular police, and the RIAA and the MPAA agents cooperating to track down record pirates like these who were arrested in New York in about, I think, 62. By the 60s and 70s, the major trade associations, the RIAA, the MPAA, in Britain, the Federation Against Copyright Theft, FACT, all have their own private police forces, essentially. They tend to be recruited from retired police officers, in this country from the FBI, in Britain from the fraud squad or the anti-terrorist unit. And they tend to not only track pirates, but lobby to make piracy a criminal activity itself. So repeatedly, when they find that their measures have infringed on the law by being too intrusive, by clamping down on privacy or something like that, the response is that they stop, but immediately Parliament or Congress criminalizes what they were going after, so it becomes the responsibility of the state police. In Britain, for example, the Federation Against Copyright Theft found that it could get secret authorization to enter and search the homes of suspects under a thing called Anton Pillar orders, until they were challenged in the early 1980s by a pirate in Luton who complained that this was a violation of Magna Carta, essentially. Same complaint that's been made for 300 years. The judge agreed, those orders were thrown out, and immediately Parliament criminalized what was then video piracy and turned it over to the police with search and seizure powers. So this has become a hybrid kind of mutually reinforcing process where a private policing endeavor gives rise to a public policing endeavor. And it's also extended across the world. By now, there are multiple international intellectual property policing organizations. And lest it be thought that I'm unduly critical of this, let me give you an example where it seems like it's actually a good thing. Impact is the global agency that's charged with tracking counterfeit drugs. I mean, medicines, not illegal drugs. Counterfeit drugs are a real problem, and they have actually killed people. And so this is a case where intellectual property enforcement needs a kind of an intellectual agency of this kind. And it needs surveillance techniques, technologies, and so forth. Now, the other aspect of this that I want to talk about just briefly is its technological arm. This too goes back hundreds of years. In the 17th century, Robert Boyle was proposing a mechanism to detect counterfeit drugs, actually. It was a precision balance. It was never put into use until the 19th century. In the 20th century, anti-piracy technologies have proliferated, and they've become in different kinds. They track different kinds of signals or telltale signs that piracy might be going on. For example, you can deploy technologies that prevent piracy by having some kind of encryption technique or photocopy-proof paper. You can put in regional codes into DVD players, which are much mocked, of course. Or you can have technologies which don't prevent, but provide a detective mechanism when piracy actually happens. Watermarking, DRM tracking, genetic markers. One of the most interesting techniques is a kind of signal that's actually intrinsic in broadcasting in the 20th century. In early broadcasting, in countries with big public systems, there was no way of tracking who was listening to the signal. This was an unprecedented problem with a medium. You couldn't tell who was receiving it. But you could actually, because early radio receivers were not very finely tuned, which meant that they resonated and they became transmitters. So if you had a directional antenna, you could actually track who was receiving your signal. And in Britain, where the BBC was supposed to have a monopoly on airwaves and to be financed by a license fee, technologies were invented to allow for the tracking of listeners for the first time without going into their houses. And this was absolutely key to the whole emergence of the BBC as a global broadcaster. This is one of the technologies. This is actually produced by a company called Secret Wireless. These are so detectives in the 1920s would be charged with going down the streets looking for an oscillator. An oscillator is somebody whose antenna resonates and becomes a transmitter. And the debate around the BBC right through the 20th century, if you look at it in the terms of these long historical contexts of intellectual property policing, is very much in those terms of access to houses, independence, autonomy, and Englishman's house is his castle. The physical manifestation of the technology is the detector van that for much of the 20th century trundled around England detecting license evaders, or license pirates as they were called. The detector van actually became not only a symbol of public broadcasting for Britons and of tyranny for Americans, but it also became the first real public pirate detection technology. These technologies have since ramified, and they exist throughout the world of anti-piracy policing. And I think what's so distinctive about that world today is the coalescence of the technologies with the globalized private-public partnership of this endeavor. So I've gone through this rather quickly. My intent really is to provoke questions in your mind about what we think intellectual property is, how it comes to be, and how malleable it may be, what its political implications are. And I think what I've said is, or I hope it's sufficient, to suggest that there is indeed a subject of inquiry here, and a consequential one. When in the 17th century, searchers on behalf of a company of printers and booksellers claimed the right to enter citizens' homes and search for signs of book piracy, it was a matter of fierce and impassioned controversy of principle, because it could be held to trample on the prerogatives of the subject. That was a central theme in the Glorious Revolution in 1688, and it continued to be a central theme in constitutional struggles through the 19th century. And nowadays, although the polity and the moral economy and the agency and the technologies are all very different, the principle is still there, and the passions for that reason are no less evident. These are some of the passions that drive Anonymous, for example. Access and surveillance remain among the most pivotal of political powers, And that's what I think is significant in the end. It's true that the properties of digital networks and genetic sciences are transformative. I don't mean to downplay those. Yet the questions raised by the anti-piracy industry, the questions posed, that is, by intellectual property in action, are paradoxically very traditional questions, and that's why they're so important. They're modern versions of problems that history has made central to modern political liberty itself. Their terms are privacy, property, accountability, citizenship, freedom. And they're among what history has told us to recognize as the fundamental elements of a just society. At the very least, I think one of the questions that we need to ask is the oldest one of policing, that is, who guards the guards? I think I will stop with that.
Anybody have a question?
I really enjoyed your remarks. I'm curious about this notion, though, of the idea of these legitimate big companies, film companies and things. They're really today employing their own private police forces, their own thugs in the form of these denial of service attacks, or the spoofers, or the whatever the media defender, places like that. I'm really interested in the whole sort of where those kinds of organizations, the media defender, for example, looked a little more legitimate or mainstream than some of the other ones you showed us. But I mean, how those organizations fit into the sort of real, the real legal environment in the modern world.
Yeah, it's not terribly clear, actually. They're edgy. You know, these companies are sometimes pushing boundaries. A media defender was pushing a boundary with its assault on BitTorrent sites that ended up targeting that television company in San Francisco, and the same with ACS Law. Media defender is you know, as it were, on the right side of the barrier, whereas it looks like ACS Law was on the wrong side. But it's not, you know, that division point is actually being defined as we go forward. But it's been fuzzy for a very, very long time. So there, you know, it's something that's you know, where the boundary of something like best practice exists in this domain is unclear, and it's really a resultant of what people can get away with, I think, to put it crudely. So the policing agencies, these things like Media Defender, I don't mean to single out media, I mean, there are many of these companies. They're commercial operations, they want to make a profit, and they want to be ahead of the game, and they want to beat their competition. That means being more aggressive and more successful than their competition in challenging pirates and taking down hackers and things like that. So they're in the business always of being on the edge of what's permissible. And that's why they're always just slightly going over and then pulling back, as ACS Law did. Righthaven is another company that's operating out of Nevada that's doing this right now. And what I want to say is that that practice is actually, you can track it back a long way. You know, before the technology of the internet, seed companies, for example, were doing this. Dan Kevlis at Yale has shown this. Seed companies were doing this in the late 19th century. They were writing cease and desist letters to market gardeners, accusing them of pirating particular hybrid versions of apples or whatever. There was no legal basis for this at all, and they just rested on the assumption that the market gardeners wouldn't know that. So there's a long history of this. And if you take intellectual property to be not just legal doctrine, but an element in everyday life, these practices are very consequential, because they can affect what we do and what we don't do as, you know, normal, only partially informed citizens. So yeah, the other thing to say is that some of these companies are actually spin-offs, of course. They come about initially as internal divisions of larger corporations, where they're initially charged with doing, you know, corporate business, and then the managers see that there's a scope here to make a spin-off company, and so they do. The creation of a kind of discrete industry of whatever internet piracy policing industry, as Media Defender calls it, that's partly a kind of spin-off product from the 80s onwards, I think.
Thank you. This is very interesting and new to me, but one of the things you read in the press a lot is a country like China, this almost seems to, do they encourage this type of piracy? I can never get a handle on exactly what's happening there, but you always hear about piracy. And then you read about countries like Nigeria where you get videos and CDs that are out almost immediately. And what's the government's role in this? Do they just close a blind eye, or is there any sort of a UN postal union type organization for this type of thing? I don't know.
Yeah, it's this is a very important question for geopolitics. Right? So, in the case of China, in terms of the letter of the law, China is actually a good citizen now. It's signed up for all the protections that America wants it to sign up for, pretty much, and it's tends to get given good marks by the World Trade Organization and things like that. The issue is everyday enforcement at street level, where, as far as one can tell, there isn't a great deal of it in China, and it's worse in places like Nigeria. Once you get into parts of the world where government's writ doesn't run very far anyway, then like Nigeria, which is really a kind of bifurcated country, you find that it tends to spring up a lot in places like that. So there are countries in Central South America which are similar to this. I think one thing to say about this is that if in Anglo-America the enforcement of intellectual property, the sustaining of intellectual property as a practical matter, raises these kinds of concerns about access and citizenship and so forth, which are richly redolent in our political traditions, it may be that everyday policing in other countries is going to raise concerns that are going to be redolent in their political traditions, and they're not necessarily going to be the same concerns. Sometimes things can be very strange. I'll give you an example, which is just me, right? This is entirely anecdotal, so I'm not sure how representative this is. But it meant something. I thought it was odd. So I went to Beijing a few years ago because I wanted to find out about the people who were actually but staffing the piracy enterprise there. I wanted to find out about the street sellers of DVDs and things like this in a kind of amateurish, ethnographic way. So I went around, spent a while in Beijing talking to these people. And at one point, I found myself talking to this pirate who had a kind of World War II motorbike with piled full of DVDs in a sidecar. And sitting on the sidecar, there was a policeman. And I thought, oh no, we're going to be in trouble here, because it's illegal to do this in Beijing. And but the pirate went and waved to the policeman. The policeman went off and stood roughly where the camera is there. And while I was talking to the DVD guy, and as you have to do, buying a couple of DVDs to kind of oil the cogs and so forth, and as I was walking away, he waved the policeman back, and the policeman sat back on the motorbike. And I thought this was odd, because in some banal sense, you assume maybe this policeman is just corrupt. After that, I was in Hong Kong, and I found myself speaking to the head of the Hong Kong government's intellectual property division. And I mentioned this to him, and he said, "How did you know it was a real policeman?" I said, "Well, I don't know, he had a uniform on." And he said, no, in China, something like 40% of people who wear police uniforms are not police at all. They're just people in uniforms. Because apparently you can rent police uniforms, or could at least, this is about 2001, 2002. You can rent police uniforms. And this is apparently done routinely for slightly fishy activities, that you get your policeman and you stick him there so that if the real police go by, they think it's being handled and so don't disturb you. Now, the thing is that, we're used to a certain kind of world where certain things are self-evident, one of which is that people in police uniforms are actually police, whatever you think about that. What does it mean to try to do enforcement at street level in a place like China, where even the police might be pirated in that sense? I don't know. I mean, as I say, this is just my one experience, but I have a sense that there may be issues, as it were, as deep-seated in their political culture as ours are in our political culture. And it would be an empirical exercise to go and find out what they are, which people have not done because they see everything from the point of view of doctrine.
First of all, I'd like to thank the students for coming this year. You've asked a number of interesting questions, and being a generation that has grown up in the digital age, I'm looking forward to hearing some more tonight. My question, though, is I believe you mentioned that during the Enlightenment, people were against the copywriting because they felt it was should be a free exchange of ideas, and copywriting would prevent that, which reminded me in your book of your period when Bill Gates presented his idea of charging people for software to the group of early computer scientists in California, and how many of them were very unhappy with his stand. And would that be a good comparison of how two different, like, enlightened groups looked at the people wanting to control it? And secondly, from that, could that be a possibility why Microsoft's operating systems are the most hacked in the world? Because you have a lingering resentment from the founder of the company.
Yeah, I mean, in the first place, I went through the Enlightenment thing very quickly. The Enlightenment actually has many different positions that people stake out about this, that run from very strong pro-property lines to very strongly anti-property lines. And it's one of those interesting things where people found it possible to argue from any of those positions to an idea of cosmopolitan knowledge. There is certainly one thread, I think, that runs from that skepticism that people like Donaldson were voicing in the Enlightenment through to skepticism about intellectual property in the modern age now. And it's not an obvious thread, but it's a real thread, and you can actually track it because you can see people reprinting his tracts actually over the years in the 19th century, the early 20th century. So it's multifaceted. As far as the Microsoft thing goes, I do think that probably a contributing reason to why Microsoft's operating systems are so hacked is that Gates and Microsoft, built up this reputation quite early on for being rather militantly proprietorial, in the way that, say, AT&T did in the 1920s and 30s, where AT&T used to have the reputation that if anybody ever invented anything to do with telecommunications, they would buy the patent in order to suppress it. AT&T always denied this, but it led to big investigations in the Roosevelt era. And Microsoft developed a reputation in the, would it be late 80s and 90s, that was very like that this was the latter-day IBM, to use another analogy. And Gates's letter to hobbyists had a certain iconic value there, because it lays out very clearly what his position is, which is that software is a proprietorial product, and that if you want professionally produced, robust software, you need it to be a proprietorial product. You can't just hand it over to amateurs and hope that the crowd will make something excellent. It'll be unreliable and unstable and so forth, which probably made more sense before digital networks, but nonetheless it was a contested thing even at that point. But I think in the end, the reason why Microsoft is more hacked than anybody else is just that it's more widely distributed on systems. I mean, that's the richest target. That's why. It's not that I think hacker/pirates really love Apple or something like that. I think it's just that Apple only has like 5% of the personal market, and you go after the one with 95%. I think that's the biggest thing. And the line, there is this idea that Microsoft, at least before Google, was the evil company, and that contributed to it. But I'm not sure to what extent that's something like a conscience-salving legitimation exercise. Don't know.
I don't know if you're aware of, we're having a really severe problem in the area of making quilts in the United States right now. It started off with a friend of mine in Tallahassee developed a gorgeous quilt based on a needlepoint pattern that was of an angel rising from the sea. The person who published the needlepoint pattern wrote a cease and desist letter. This quilt was selected to be in the Paducah Quilt Show, which was the major quilt show in the country. The quilter was told that she could enter the quilt, but it could not be judged. It could not win a prize because it was a violation of this pattern, because you could not take a pattern and use it in another medium. And this was the first I think any of us had heard of it. Interesting enough, this quilt was selected as the #1 most popular quilt at the show, although it did not get a prize. Since then, we have been hearing constantly publications and restrictions that we can now, your grandmother, when she makes a quilt, if she happens to put that out in the church bazaar, and it was from a published pattern or magazine, they would be committing an illegal act. And it's greatly repressing our quilters. And we are no longer allowed to sell any of our quilting at quilt shows. You can only show a quilt if you have an original pattern or you have a written letter from the person who did the initial pattern, or it's incredibly boring and traditional. So this has just really been very repressive, and it's really cutting back on the quilt clubs and fundraising opportunities and opportunities for shows and people doing quilting, which is one of the most popular hobbies in the United States. To further complicate this, the Smithsonian sold a bunch of the American quilting patterns to the Chinese, licensed in Chinese, which the quilters have been very upset and angry about. That was about 15 years ago.
Yeah. Well, that's fascinating, and that's a real example of how something, a deadening effect of that kind can be produced without necessarily there being any change in the law itself. It's entirely to do with how the law is actually appropriated and put to use, or even not necessarily even appropriated and put to use, but just kind of evoked in some way, right? Yeah, because nobody sane wants to be involved in any kind of legal process in this country. It's, and the same in other countries too. But so you can do this and kind of get away with it, as it were. And groups, of course, institutions tend to be very cautious. So if the possibility exists that there might be some kind of possibility of infringement, then they'll take the side of caution and just not do something. And it's particularly ironic, of course, that it would happen with quilting, where the whole ethos and the communitarian character of it is so marked, right? Yeah. Yeah. I mean, quilting really has been this is an academic thing to say. Quilting has been the acme of something like an artistic craft, where the ethos of it is very different from the high arts, but it's nonetheless an artistic thing that has values, quality standards, and so forth, all those things that in some ways one associates with the arts. It was one of I think this is right, it was one of the models in this classic book called Art Worlds that came out about 20, 30 years ago by a sociologist, Becker, which details these kinds of communities. So it's especially ironic if that is being hit by this kind of evocation, I think.
Hi, thanks for coming. I really enjoyed your talk. I wanted to know if you could speak on behalf of the future of intellectual property law enforcement, specifically regarding the millennial generation and the fact that technology is advancing so quickly, and kind of with each consecutive generation, there's a new gadget that you put in their hands, and it's so easy for them to access all this data and all this information, and the fact that it's not common knowledge to many that what they're doing is construed as illegal, and kind of how that can be combated, whether through education in schools or maybe a tutorial when they first get the product.
Yeah. Yeah, no, that's an excellent. I do think that. Okay, a couple of things about this. One is just that, in some ways, I'm relatively optimistic that as it were, the hard-line absolutists of intellectual property are not going to win in the end. I think, for example, it's quite likely that some solution to the orphan books problem that brought down the Google Books settlement will be found, if necessary, by Congress. And I think it's quite likely that the excessively long term of copyright will be kind of wound back somewhat in the future. So I think that we're not necessarily on a trajectory towards ever increasing protections and therefore ever more constrained, uses, as it were. That's one thing. But the other thing you asked specifically about schooling, I think, is critical. I think that we're at a point now where the responsibilities on the education system, running right from early education through to the universities, are really huge and transformed. They're not the responsibilities that existed 25 years ago. We need to inculcate in what did you call them? The millennial generation, the next you people. We need to inculcate them almost a new form of critical reading, which is not limited to things like knowledge about intellectual property systems. It has to do with the digital to core, where one learns to see, as it were, through facades, through screens, to how it is that the flashy appearance of things is actually constructed and manufactured, and what limits and enablements have existed to make things appear as they are, not just take them as flashing in front of your eyes and, as it were, impinging on you. This is the new form of critical citizenship that, in a way, English literature was institutionalized in the early 20th century to deal with then. We need something like that now. And a critical sense of intellectual property would be part of that. And it certainly wouldn't mean just telling people what the laws are and saying, this is what you can't do. It would involve telling people what the laws are, surely, but also telling them how the laws came about, what they mean in practice, because they're very, in practice, they're very, they only get clear in practice, put it that way. And you see that especially with something like fair use, which is notoriously fuzzy. Fair use was not given a formal definition until the late 1970s, even though it existed in some form for at least 150 years before that. And even now, categorizing something as fair use or not fair use is really a product of quite sophisticated tacit knowledge. But what's true about fair use is also true about lots of things that we take to be much more doctrinal. Inculcating into the next generations an ability to work with those systems, protocols, practices, and so forth is absolutely key. I don't know where it's being done, and or if it's being done, really. In some ways, this is a rather a conservative thing to say, right? It is a call for something like a revival of the ethical values of close reading in a certain limited way, but it's more than that because it has to do with excavation of things like coding techniques in HTML, to put it crudely. Sorry, that's a very, I guess, wider answer probably than maybe you were looking for. But.
Well, I guess that was the last question. Thank you again for coming. Thank you so much, Professor Johns.
Thank you.
And you're very...